Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about change of venue and how it works in any given situation. And I'll try to explain some of the inside baseball with regard to change of venue. So the first thing we need to talk about venue is that it's the site where the case is tried. Now, in most places, that's the county seat. It doesn't always have to be that. Sometimes there are multiple courthouses. For example, in Jackson County, Missouri, there are courthouses in Independence and in Kansas City, and you could have your trial in either of those two places, depending on other factors that are a little bit too much in depth to go into here. But the bottom line is you can sue or be sued in any county pretty much where you do business, and if you get sued, it is the plaintiff who has the initial choice of venue. That doesn't mean that you're going to get stuck in venue, and it doesn't mean that there's not a remedy if the plaintiff picks the wrong venue. But it is an uphill battle to change venue in many cases. So let's talk a little bit about how venue is decided. In most cases, there is a statute directly on point in the state that tells you what the venue of a lawsuit is. For example, in Missouri, if it is a tort lawsuit, it's where the injury was first felt. So, for example, if two people are driving down the road, one of them is from Kansas and the other is from Boone County, Missouri, and there's an accident in Cole County, Missouri, the venue for the lawsuit is going to be Cole County because that's where the accident happened. Now, other states have different rules, and the federal rules are completely different, and you can go brush up on those if you would like. But most of the time, plaintiffs do not sue in federal court. They may wind up getting pulled into federal court through what's called a removal, but for the most part, they don't sue in federal court because federal courts tend to be antagonistic in some respect to plaintiff claims. That's just the sad truth about how courts operate. The interesting thing about federal courts is they were initially designed to sort of negate the hometown advantage, but for the most part, they don't even do that now. All they really do is set up sort of a procedural mechanism that essentially emboldens the defendant to hang on till the very last minute before they settle. That's in the civil context. What about the criminal context? Well, again, in the criminal context, there are statutes directly on point that deal with where the venue is, and usually that's the case where the crime was committed. That's because you don't want people in St. Louis deciding about a burglary that went down in Kansas City. They would have no familiarity with the area. It's just not the way the world works. So venue is usually in the place where the crime was committed. But again, not always. Let's take a little look at what's going on with Brian Kohberger. Now, Kohberger, that's a case that has an awful lot of interest. There's been an awful lot of media in it. I've done some videos on this Ashley person who decided that a local professor at one of the universities was to blame for all of this. And there's just been an awful lot of interest and an awful lot of publicity. And unless you've been hiding under a rock or in a cave in Afghanistan somewhere, you know who Kohberger is and you know what it is alleged that he has done. It would be difficult to find any place in Idaho, and even more difficult to find any place in the United States where somebody hadn't heard about that particular case. But that's not the key element in a change of venue. The key thing in either a civil or a criminal context is whether you can impanel a fair jury. Now, a fair jury is not necessarily an ignorant jury. You, for example, probably wouldn't want somebody who's been hiding in a cave in Afghanistan on your jury. You would want somebody who was reasonably bright, reasonably focused, and willing to pay attention. What happens in voir dire is The lawyers get to ask questions to determine whether or not there is a bias or a prejudice against a particular party or parties. That's in the civil context. It's also true in the criminal context. The state gets to ask whether or not anybody on the panel could refuse to apply the death penalty, because in Kohberger's case, I believe they've decided they want to go for the death penalty. If somebody has a moral issue with using the death penalty or affirming the death penalty, then in most cases they're not going to be selected for that jury. They will be stricken for cause. Again, this gets into the jury selection part, but that's how you deal with a situation where somebody has a bias or a prejudice against the defendant. And it's the art of questioning. It's the art of the lawyer asking tough questions and drawing allusions and drawing people out, getting them to speak. That's what really allows a lawyer to determine whether or not there may be some bias or prejudice. And even if he can't get somebody stricken for cause, in other words, they stand up and say, I don't care what the evidence is, bring him in, we'll give him a fair trial, and then we'll hang him. That's the guy you don't want on the jury because his mind is closed. There are all kinds of studies that say you want women on the jury. There are all kinds of studies that say you want a certain kind of man on the jury. There are all kinds of studies that in different situations you want people with high levels of education, and in other situations you want people with low levels of education. And the bottom line is a good jury is a cross-section of the community. You can be a nuclear physicist and be as clueless in terms of common sense as anybody. And a lot of what goes on in a jury room is common sense. You have to have the common sense necessary to put the two facts together to come up with the answer. So you want people who are a good cross-section of the community, and even though they have heard the news, even though they know what the allegations are, even though they know that was a horrible crime out there in Idaho, you want somebody who's willing to sit in the chair in the jury room and say, yes, I am willing to sit here for 4 to 6 weeks. I'm willing to listen to witness after witness after witness tell me what happened. I'm willing to adjudge their credibility based on what they say and all the other factors that go into it, the examination and the cross-examination. I'm willing to turn over in my mind all the things that they say and give it a fair hearing, and then I'm willing to reach a conclusion about guilt or innocence. I have not made up my mind about guilt or innocence, and I do believe that everybody is entitled to a fair trial and that people are presumed innocent until they're proved guilty. In essence, what you want is a jury very much like Casey Anthony had. Casey Anthony, there was an awful lot of smoke in that case, right? That sort of indicated there was a fire, but the prosecution never nailed down the fire. And that's where they screwed up. They proved that Casey Anthony was a liar. Okay, she's a liar, but being a liar doesn't necessarily make you a murderer, and so they acquitted her on the murder charge because the state never brought it home. Well, that's what you want in a jury. But sometimes, particularly in small rural counties, you just can't get that. Now, one way to establish that is through affidavits or through an expert. You hire an expert to do a jury survey, and what they do is they call people at random in the county, and they ask whether or not they've made up their minds. Is there any way they could, set their feelings aside and be a juror in the case? And based on the results of those surveys, sometimes you can establish that you're not going to get a fair trial. Other times you bring in affidavits from different people throughout the community that say, yeah, none of us are going to be able to sit in judgment of this guy, or please let us sit in judgment of this guy because we think he did it. That's really the kind of person you want to avoid having on a criminal jury. So experts get involved, you get affidavits, but most importantly, and the thing that really, in more cases than not, determines it, is what happens on the first, second, third, and fourth days of jury selection. If you get people in and they're like, nope, I'm pretty sure he's the guy. I mean, I've heard from a whole bunch of stuff. I've heard all kinds of rumors, and I tend to believe that he's the guy. So you dismiss him. You go to the next person. Oh, yeah, he's the guy. Next person. Yeah, no question about it. He did it. I mean, we'll give him a fair trial. We'll listen to this stuff, but you know he's guilty. Well, if you go through, 3/4 of your panel of jurors that have been summoned and you haven't gotten somebody who will sit on the jury, you've got a real problem. That doesn't mean that people can't acknowledge that they have a bias. For example, people might say, well, anybody that would just knife somebody to death in their sleep is an awful person. I don't know how I feel about that person other than I don't want to have anything to do with them. Well, that's an acknowledgement of bias, right? But that's not disqualifying, because the very next question will be, well, do you think you could put aside that animosity and reach a fair jury verdict in this case just from the evidence that comes in from the stand? And if the answer is yes, then you can seat that person in the jury. And if the answer is no, then you move on to the next one. That's the methodology you use to get a jury in any kind of case, really. But more importantly, in this criminal case, what you do is you'd have to go through and you'd have to laboriously question about whether or not all the facts that they'd seen, whether that pushed them one way or another, whether they could remain, unbiased. And in some cases, when there is just a high heat level where it's going to be really hard to get those people in, a lot of times what happens is you still have the trial in the city or the county where the venue is set. But what you do is you bring in a jury from a neighboring county. And you bring them in and you seat them in the seats and you do the voir dire with them. And usually because they're a county or two over, they have not been in the rumor mill as much. And so they may understand things a little less well than some of the people who live there in town. And as a result, you're more likely to get a fair jury. Now that increases the cost for the state. That places a huge burden on the people who are summoned from the neighboring county. They're going to be picked up at, probably 7 o'clock in the morning, driven to the other county on a big bus, and then that bus is going to pick them up and take them back to their house or back to the pickup place at the end of the day. And if they are indeed sequestered when they get ready to try the case, then they're probably going to be housed in the county where the venue is, and that's going to disrupt family life and that sort of thing. So there are issues, many issues one way or another, regardless of how you get your jury pool for a particular case. It is highly unlikely that you will get a jury from a neighboring county when you're doing a civil lawsuit, because the stakes are not as high. It would be an awful thing to lose a civil lawsuit because everybody in the town just loved the hospital there and couldn't believe that anybody at that hospital would screw something up. It'd be awful to lose that case, but that happens 4 or 5 times every year in cases all throughout the country. It happens, it shouldn't happen, but it does. And while that's awful, particularly for the people who may have lost a lot, it isn't necessarily the kind of thing that needs to be remedied by bringing in a jury from another community. And that's because a jury is considered to be the conscience of a community. It's considered to be the people who speak about what's right and what's wrong in the community. So one of the things we often tell juries, look, you're going to act as the conscience of the community. You are going to sit here and you are going to decide if somebody made a horrible mistake on this day. Now, that doesn't mean that they're a bad person. It doesn't mean they're evil. It just means they were careless. Are you able to do that? Are you able to sit in judgment of the acts of another human being? And as difficult as that is for many people, it is the only way to actually get a fair resolution of a dispute. And certainly in the context of a criminal trial, it is the only way to get a fair jury, which is to seat them and ask them and trust in the integrity of the jury. And there's good reasons to trust in the integrity of the jury. Parkland officer case. Kyle Rittenhouse, another example of jurors who thought long and hard and reached the right conclusion. And this is what we expect of jurors. And the reason that we have the change of venue rules is to make sure that any local prejudice that is so strong can be overcome by getting a jury from another county. So that's the whole kit and caboodle on changes of venue. If you have any questions, leave them in the comments down below. You know, we always ask you to like and share and subscribe and do those kind of things. I'd really appreciate it if you would do that. Otherwise, if you have the opportunity today, take some time and send somebody a note or an email and tell them what a good person they are and how much you appreciate them. Because one day that may matter a great deal to them. So thank you again for watching. Have a marvelous day and catch me down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.